raised that.
Very good. In that case, please proceed.
I'm very grateful. On the prosecution's part, we are not inclined to oppose the application by the government of Kenya to be heard in this matter. We wouldn't wish to stand in their way. It seems plain from the agenda circulated and from Your Honour's remarks this morning that this is not a hearing at which any decisions by the court will be made, let alone announced. The purpose is for the court to be informed of the parties' submissions, briefly, in supplement to their written submissions. If I anticipate correctly that it was never the intention to announce any decision on the competing submissions today, as I say, the prosecution doesn't seek to stand in the government of Kenya's way. What we would submit is that if you are indeed to accede to their request to make submissions, you should set a tight timetable for them to do so within a few days and take those submissions into account, if they are helpful, when formulating and deliberating the judgment which you will ultimately make on the parties' competing submissions. But I would wish to add this. There are two distinct issues as will emerge from the submissions to be made in this hearing. And it may be difficult to see how the government of Kenya's submissions in this context will assist the Chamber in determining whether they should accede to our application for an adjournment or to the defence's application for the matter to be dismissed. The government of Kenya is going to have its opportunity to make submissions on the matters about which it's concerned in the proceedings to which they are fully a party, that is, the non-cooperation submissions, which run in parallel to these proceedings now. And it's fully open to Mr. Kenyatta, through his counsel, to argue any of the issues which are raised in the government of Kenya's filing, if he thinks it will advance his case. It's difficult to see how submissions by the government of Kenya, as prefigured in their document, which appear to be that doctrines such as the separation of powers or the Constitution of Kenya itself will advance the Chamber's understanding of the issue here, which is simply, should the case be adjourned or should it be dismissed? One difficulty which both the government of Kenya and, if it's thought right by Mr. Kenyatta's representatives to raise the arguments, is the provisions of Article 132, sub-Article 5 of the Constitution of Kenya. The Kenyan government's position appears to be that there is a separation of powers, which means that what the prosecution has said about Mr. Kenyatta's involvement in non-cooperation is inappropriate. But I draw to the Chamber's attention the provisions of Article 132, sub-Article 5, which are, quite simply, and I have copies if that would be useful, but it's very short. The President shall ensure that the international obligations of the Republic are fulfilled. And I draw that to the Chamber's attention.
Mr. Gumpert,
Yes.
sorry to intervene, but I don't think we need to go into detailed discussion about Kenyan law at this status conference.
I'm glad to hear it, Your Honour. I wanted
And
to
please be assured that the bench has no intention to make any decision
Yes.
at today's status conference.
Well, I'm grateful. I don't propose to go into Kenyan law to any greater extent than I have, only to ensure that the bench is apprised fully of the position when it considers the merits of the application made by the Kenyan government.
Thank you very much. Defense, do you have anything to say about the specific point of Kenyan government's request for leave for amicus curiae?
I do not, Your Honour. It's not an application that was caused by us. The matter before the court today was quite clear on the status conference agenda, and the matters raised within that filing of yesterday in my submission shouldn't divert the court from the consideration of the clear issues before it on behalf of the defence.
Thank you very much. Legal representative.
Thank you, Madam President. We do not oppose the request of the Government of Kenya of the 4th of February 2014. Thank you.
Thank you very much. I think now we can move on the other agenda items. We turn to the prosecution request for adjournment contained in filings 875 and 892, and the related defense request for termination contained in filing 878. But before we start, I would like to ask all parties and participants, please do not repeat their written submissions, and to only raise any supplementary submissions they may have, including arising from the prosecution's most recent filing on Friday. But before going into discussion, prosecution, as an initial matter, I think it would be helpful if you could clarify the status of your original request in light of the new request contained in filing 892. Is your original request 875 superseded by 892? In other words, are we to understand that the new request for adjournment of the trial pending compliance by Government of Kenya with an outstanding request for assistance is intended to entirely replace the earlier request for 3 months adjournment?
In essence, the answer is yes. The difference between the two requests is that the earlier request was limited in time to a period of 3 months. Speaking frankly, the 3-month period was no more than the best rough estimate which we could then come up with, hoping, as we then did, that the investigative steps which we outlined to the court might bear fruit. We tried to calculate forward how long, if they did bear fruit, it might take us to have the material ready to serve on the defence, how long it might take them to be able to react so as to be able to counter any such evidence, and came up with a date by no very scientific method 3 months beyond the trial date originally fixed. As I made clear, I hope, in response to Your Honour's very first question, those investigative steps have not borne fruit and cannot reasonably now be expected to do so. And so the prosecution is thrown back upon other matters which it did raise in that initial filing. Principally, the submission that the Government of Kenya has obstructed this investigation by its non-compliance with requests for assistance. Our submission is that if that finds favour with the court, and if it is right that the trial should not be, that the prosecution should not be withdrawn until there has been compliance with that very important request, obviously a time limitation would not be appropriate. The trigger for further consideration of whether the matter should be withdrawn would be compliance by the Government of Kenya. As I see it, the trial is currently adjourned, to use the Latin phrase, sine die. That is to say, no date has been fixed for the hearing. That, of course, was a temporary measure, as Your Honour has made clear, to enable the bench to consider fully the matters raised. But the request which is now before the court from the prosecution is that the trial should continue to be adjourned without a date being fixed for the opening of the trial until such time as the government of Kenya complies with its treaty obligations under the Statute of Rome.
Thank you very much. Another question. As I made it quite clear, we do not wish today to enter at all into the substance of Article 87.7 application, which is also pending before this chamber, and we would ask all parties not to do so. However, the bench needs one clarification from prosecution. Could you clarify what you consider the primary purpose of the non-compliance related requests included in filing 892 to be? Are they aimed at attaining relevant information in an attempt to reach the required evidentiary standard, or are they aimed at seeking some consequence for the alleged non-cooperation by the government of Kenya? And please confine your answer to the specific point I asked. What's the intention of your request contained in 892?
I hope I won't be impertinent if I say that the prosecution does not view it as an either-or situation. The prosecution seeks both results. The particular failure to cooperate which we allege concerns something which may be very significant. Taking it very shortly, because I'm mindful of Your Honour's injunction, one of the allegations we make against Mr. Kenyatta is that he personally provided very large quantities of money which were funneled down through his intermediaries and messengers and delivered in the form of cash to the perpetrators of the violence. The request for assistance which we made was for Mr. Kenyatta's financial records, because, we suggest, if he did indeed make such financial contributions, there would likely to be records of movement of funds at the relevant time. It in fact would be important both for the prosecution and the defence. If there were no such movements of funds, that would be a cardinal point to suggest his innocence. On the other hand, if there were unexplained movements of large amounts of money, that would tend to support the prosecution's assertions. And so the answer to your first query, the either, if I can put it that way, is yes. Although we do not know what is contained within those records, only Mr. Kenyatta knows that at the moment, we were hopeful that considerable and important light would be cast upon the truth of this matter, whether he was or was not involved in the violence which followed the election. But in addition to that primary purpose, that is to say, to seek important evidence which will reveal the truth in this matter, or better reveal the truth in this matter, we also consider it to be of great importance that states parties are held to the obligations to which they signed up when they became states parties and submitted themselves to the jurisdiction of this court. One of those obligations is to assist the court when requests for assistance are made, and to use all the powers of the state to provide information which is properly asked for. It's nearly 2 years now since we asked for this material, and we characterize, I use a one-sentence summary, the position of the government of Kenya as pure obstructionism. If that is right, And as Your Honour has said, those are completely parallel proceedings, and I shan't seek to advance my case in that matter any further. But if that is right, if Your Honours conclude that the prosecution's submissions are correct, and that the government of Kenya is in breach of its treaty duties, it is vitally important that that is seen to have consequences, that states parties who find it inconvenient for one reason or another to comply with their duties and to supply information are seen to be held to account, are censured by the court, and that their failure is referred to the Assembly of States Parties. So I apologize if I sound greedy, but the answer to Your Honour's question is not one thing or the other, but both.
Thank you, prosecution. Just as a follow-up, do I understand correctly that even if the government of Kenya were to comply with the outstanding request for financial and other information, the prosecution is not sure whether this would result in evidence which would allow you to proceed to trial on the basis of current charges? Am I correct?
Your Honour is absolutely correct. We do not know what is contained within those financial records. I hope a moment ago explored the two possibilities. One is that Mr. Kenyatta's bank accounts are in a stasis, that nothing's happening, which on the face of it would be highly suggestive of his innocence, at least of his non-involvement in the way we have suggested. Or alternatively, there may be unexplained movement of large amounts of money. We don't know the answer to that because the government of Kenya has prevented us from finding out. So we don't know whether it might yield evidence which would enable us then to say that our case was strong enough to bring before the court.
Sorry to ask the same question again, but that means the financial information about the movement of the funds, do you think it's enough to sustain your charges even without witnesses 11 and 12? Is that what you're saying?
It's a very hard question to answer. Your Honour is asking me to speculate about the content and nature of material which I don't know because we've been prevented from seeing it. I don't rule out the possibility that full disclosure of Mr. Kenyatta's financial records, if indeed our case theory is correct and that he is involved, but just at the moment we don't have the evidence to prove it, I don't rule out the possibility that such evidence might be sufficient to enable the case to be brought. But that really is just the wildest speculation. It's obvious, equally, that it might well not permit the case to go forward, or even, as I have prefigured, that it might, if not demonstrate his innocence, at least strongly suggest it. All the more reason why we say, before this case is withdrawn, if it is to be withdrawn, that information, potentially crucial either way, in fairness, is obtained.
Judge Freeman has a question.
Mr. Gumpert, I would like to ask you, a part of this I would call it direction of prospective further investigation concerning Mr. Kenyatta's assets. Do you have also an intention to conduct further investigation in some other direction?
Our current position is that of the leads available to us, we have exhausted all reasonable prospect. We're under a duty to continue our investigations. Mr. Kay, in his written pleading, speculated, quite rightly, that as the matter goes on, other people will be coming forward, other potential leads will emerge. And indeed, as we acknowledge in our most recent filing, they have. And we're under a duty to continue to follow those matters up. and to investigate. But we have to take a realistic view based on our experience as prosecutors. At some stage, whether we consider that they're on the basis of which, to borrow a phrase from the other Kenya proceedings, which stones could still be turned, the stones get less and less promising. And we've made a decision that, absent the financial records of which we have spoken, the remaining stones unturned are better characterized as pebbles, and the realistic prospect that turning them will yield real, potentially conclusive evidence is minimal.
Thank you.
Thank you very much. Prosecution, is there anything additional you'd like to add to your written submissions before we turn to defense?
Apologies. Your Honour spoke at the outset of this hearing of consolidated submissions. My submissions on the reasons for the court adjourning this matter are complete within the document. We have also made submissions on why it would be premature to consider the applications made by the defence. That is to say, that the court should terminate the proceedings using its powers under Article 64(2) of the Rome Statute. If I were given the choice, and given that, as I understand it, we're not pressed for time because we have the afternoon available as well, if it is necessary, I would prefer to make my submissions in response to the defence applications, having heard Mr. Kay, since it is his application to which I respond, rather than making all of my submissions now ab initio. But of course I'm in the court's hands.
Thank you very much. Well, in that case, I think we should turn to defense.
Apologies for interrupting. On the basis that, in respect of the submissions made by the defence about dismissing the case, I can reply.
Oh, yes, of course.
I'm very grateful.
So defense, we note in particular that there were a number of new issues raised in the prosecution's filing on Friday, and we'd like to invite you now to make any submissions in response to those issues, as well as anything you'd like to add to the written submission you have already made. And please try to confine your submission at this point to no longer than 30 minutes.
Thank you, Your Honour, and I'll certainly be able to do it within 30 minutes. Your Honour is quite right to observe that these were new submissions by the prosecution that were put before the court on Friday, and they evidenced a change of direction and the way it was submitted, and has indeed been submitted today, is the proposition that the responsibility for the failure of the case and the fact that there is no evidence lies at the feet of the government of Kenya for failing to comply with requests by the prosecution. Your Honours will have been seized of this matter in far more detail than me, because I have not been an active party within the proceedings between the government of Kenya and the prosecution. but it simply comes down to this, as to whether there is any merit in this shift in direction, that the government of Kenya has maintained consistently since 2012 that requests from the prosecution should come through the court, and by that they mean the trial chamber. And that has been a consistent position that it has advanced over the last 2 years, and made it clear to the prosecution that there are issues of national law that have to be considered if the prosecution are approaching them, and that there is an entirely different position if it is the court under Article 93 that makes the request. Why I say this has become a change in direction at a convenient time when the prosecution has realized that its case has collapsed, is that in the 2 years since 2012, the prosecution never came here for a ruling upon the matter. It just continued a series of letter battles with the government of Kenya, and didn't seek clarification of the issue. The court will know that Article 93 refers to national procedures as well as requests from the court. And it's that key phrase, the court, which has been of greatest concern to the government of Kenya, a member of the Assembly of State Parties, in the interpretation of the correct procedures. Within Article 93 itself, there is reference to the court and the prosecution making a specific provision for actions and conduct that may be taken by the prosecution. But in the key section that we're dealing with in Article 93, Article 93(1), it doesn't refer to the prosecution. The position of the government of Kenya may not be unreasonable on this matter. Other tribunals also have a similar procedure available to them, and Your Honours may well know Article 54 at the, or Rule 54 at the International Criminal Tribunal for the former Yugoslavia, which refers to the chambers issuing orders and requests. And having received this filing on the Friday, a quick survey of the various procedures that exist in other institutions to see whether the government of Kenya interpretation of Article 93 was unreasonable or not, revealed that indeed they always specify the chambers or the prosecutor, or in the case of the Cambodian court, the investigative prosecutor. There's always a title which is available to describe who may take the requisite action. And this matter has been repeatedly made to the prosecutor over the last 2 years, and the issue was not pursued if it is such a valuable issue to the prosecutor in relation to the case. So our submissions on the matter of the conduct of the government of Kenya are that their position has not been unreasonable. To jump a stage and to start seeking orders before the Assembly of State Parties, to start measures critical of Kenya, in our submission, is high-handed. And the prosecutor itself is an organ of the court. It is not the court itself. And any reasonable interpretation looking at Article 93 brings into force that distinction between the two, and it is not unreasonable for international lawyers looking at the precise powers that are being sought here to interpret the way it has been. Our submission is essentially this, that the very nature of the filing on Friday is more of a convenient vehicle to try and stop the case, but without admitting who has failed here. It's a blame-shifting exercise onto the state at the expense of the prosecution. And in our submission, that is not right, and it's not fair, and it's not reasonable at this stage, given the apparent failure for all who've been observing these proceedings of the allegations that have been made concerning the common plan. I don't know how much Your Honour wants me to go into those aspects at this stage. Safe to say that in relation to the government of Kenya issue, that is our clear position, having looked at the filings and considered the matter, and having seen the dispute between the two sides.
I think, Mr. Kay, you have said enough about government of Kenya non-cooperation issue.
Thank you very much.
Thank you very much. May I now turn to legal representative victims? You may now make any additional submissions you wish in relation to the pending matters. But please be mindful that we are in open session in case you wish to engage further regarding the details of any of the prosecution's responses to the specific questions you had raised in your previous filing. Again, please try to confine your submission to no longer than 30 minutes.
Yes, Madam President, thank you very much. In view of the gravity of the issues raised today, I would request a little over 45 minutes to make my submissions. The defence's application, if it is granted, will mean the total extermination of the victims' rights in this case. And given the exceptionally important nature of today's proceedings, I would ask for the benefit of just a few extra minutes.
Okay.
Thank you very
Please
much,
proceed.
Madam President. Let me just very quickly deal with an issue raised by Mr. Kay. I would note that the obligation is not on the prosecution to bring the matter to the child chamber. The obligation is on the state under both 93.3 and under 99.4b to consult with the court The word used in one of those is promptly, the expression used in the other is without delay, and we can see that the government of Kenya certainly hasn't acted promptly or without delay in seeking to consult with the court on those issues. I'll turn to my submissions now, Madam President. When a machete lands on a human head, it can take many blows to kill. That became clear to victim 9309 one morning in Naivasha in January 2008. He had tried to escape his house, but Mungiki found him, hacked him repeatedly with a machete, and then left him for dead. When I first met him 5 years after the attack on him, his head bore deep, deep scars, and part of his skull appeared to be hanging on by a miracle. On the evening of the attack, as he lay helplessly in hospital, he telephoned his wife, who told him that after he had left, she had been gang raped by Mungiki, then doused in paraffin and set alight. Both of them were lucky to escape alive. Both of them want this trial to continue. During 2013, I held a total of 30 meetings in different parts of Kenya with 585 victims of the crimes charged in this case. What happened to them in Naivasha and Nakuru in January 2008 is a nightmare from which many are still trying to awake. In meeting after meeting with them, it became clear to me in forceful terms that they overwhelmingly support the continuation of this case. Some do feel demoralized and betrayed, but many repeat the view that the truth must come out, whatever it takes. The victims want your honours to take all measures available to you to ensure that the truth emerges. This case takes place in unique circumstances. The accused is head of state and head of government. He has simultaneously presided over a high-profile international diplomatic campaign to discredit this court, a policy of obstruction of access to evidence by the ICC, which has impeded the emergence of truth at the international level, the deliberate non-prosecution of post-election violence crimes in Kenya, which has impeded the emergence of truth at the domestic level, and the pursuit of a strategy of delay in these proceedings, combined with an increase in anti-ICC rhetoric, which has exacerbated the climate of fear among Kenyan witnesses. The combined effect of this has been to seriously hamper the emergence of the truth, both at this court and in Kenya, regarding who is ultimately responsible for crimes committed during the post-election violence. To terminate proceedings in these circumstances, without first securing the full cooperation of the accused and his government in respect of access to evidence relevant to this case, would be unconscionable. Imagine a domestic case involving the systematic rape and murder of 20 victims in the space of 1 week. In such a case, the police would be expected to arrive at the scene soon after being informed of the crime and take careful steps to preserve forensic evidence. They will interview and re-interview dozens of witnesses. The prosecutor will swiftly obtain authorizations to gain access to all relevant documentary evidence, including all relevant cell phone data. On the basis of that evidence, the police will arrest suspects and question them. Police and prosecutors can count on the cooperation of other law enforcement agencies in that jurisdiction, backed up by a supportive state apparatus, in seeking access to all evidence which will enable the truth to be revealed. Anyone suspected of bribing or intimidating witnesses will be swiftly arrested. State authorities will offer full support to the investigation. If at the end of that process it emerges that there is insufficient evidence to proceed against the charged person, it is only right and proper to withdraw the charges. That's what should happen in an ordinary case. Your Honours, this is no ordinary case. None of the elements that I've just identified have been present in this case. This is a case involving an extensive set of steps taken by the Kenyan state, headed by the accused, to obstruct the emergence of truth and the course of justice. In this case, far from helping the investigation of the crimes, the police were implicated in the crimes, and the state obstructed interviews of key officers. The National Commissioner of Police was himself charged. He obviously had little interest in facilitating access to evidence, which might further incriminate him. Instead of immediately searching for, seizing and delivering key documents, the government has been dilatory and obstructive in providing documents and has deliberately filtered out those which appear to be most capable of revealing the truth. It has put forth bizarre and contrived legal arguments to justify its failure to cooperate. The prosecution was deliberately misled as to the availability of cell phone data, obstructed in trying to access it, and when it did access it, some of it, it was provided with fabricated data. This entire investigation and prosecution has been infected with unprecedented levels of witness intimidation and interference. Instead of giving legal, logistical and moral support to the prosecution of this case, the accused has devoted enormous resources to bringing it to an end. Instead of calling on others to come forth and assist this court in its search for the truth, he has tried as hard as he can to delegitimize this court in the eyes of his own citizens and other African governments by launching vitriolic attacks on the integrity of the court itself. It is perhaps little wonder then that after thousands of hours of work by prosecution investigators and lawyers and the expenditure of untold millions of euro, that the ICC's most high-profile case has suffered such a devastating series of setbacks. Your Honours, this case has come to a crisis. At the heart of the crisis are two issues. First, the question of the sufficiency of the evidence in this case. Second, the question of cooperation by the government of Kenya. These are not two distinct, unrelated questions. They're two sides of the same coin. The accused presides over a government which has single-mindedly pursued a policy of obstruction of access to any evidence which is likely to reveal the truth in this case. Simultaneously, he has obstructed the emergence of truth in Kenya by presiding over a domestic process of accountability which is deliberately going nowhere. In tandem with these policies, the accused's venomous attacks on the integrity of this court have fed the flames of anti-ICC sentiment in Kenya and exacerbated the climate of fear. This too impedes the emergence of the truth. Let us remind ourselves briefly what has happened in this case. In 2011, the prosecution tried and failed to persuade the pre-trial chamber to confirm charges against the former police commissioner, Mohammed Hussein Ali. In March 2013, the prosecution informed the court that, in the context of witness bribery, intimidation, and state obstruction of access to evidence, it no longer had evidence to proceed to trial against Mr. Muthaura. In December 2013, the prosecution informed the court that it no longer had evidence to proceed to trial against the accused. The core reason for this extraordinary series of events is state obstruction of access to evidence. From well before the confirmation stage, the government of Kenya, under President Kibaki, pursued a policy of pretending to provide full cooperation to the ICC and pretending to move towards genuine accountability within Kenya itself. The accused was Deputy Prime Minister and held a key portfolio as Finance Minister in the Kibaki administration. He and President Kibaki were the two most senior Kikuyu politicians in that administration. Since his election as President in March 2013, Mr. Kenyatta, as President, has been constitutionally required to ensure that the international obligations of the Republic are fulfilled through the actions of the relevant cabinet secretaries. And as I've noted in my written submissions, it follows that any continuing failure by Kenya to fulfill its obligations under the statute, including any obstruction of access to relevant evidence, must be attributed to the President of Kenya. Let us focus first on steps taken by the accused as head of state, of a state party to the Rome Statute, to comply with the spirit of the statute and in particular to encourage complementarity in Kenya. As President, Mr. Kenyatta has unleashed a diplomatic campaign of startling hostility directed at trying to reduce support for this court in an effort to help him escape trial. When he took office, he knowingly assumed the responsibility to secure access to justice for all Kenyans, in accordance with Article 48 of the Constitution. But vast sections of the state apparatus were mobilized in a rigorous and energetic defense of the rights of those 3 Kenyans standing trial at this court, totally ignoring the right to justice of the hundreds of thousands of Kenyan victims of the post-election violence. Instead of using state funds to provide fair compensation to victims, the accused used state funds to send high-level teams of diplomats around the world. They travelled to the African Union in Addis Ababa, to the UN Security Council in New York, to the Assembly of States Parties in The Hague, to argue for immunity, deferral, or for rule changes on his behalf. At the ASP in November 2013, the large Kenyan delegation, including the Attorney General, the Director of Public Prosecutions, the Minister for Foreign Affairs, and the Permanent Representative of Kenya to the United Nations, used their status as state representatives to promote those amendments which were favourable to the accused and to oppose amendments to Rule 68, which aims to permit the admission at trial of evidence of a witness who has been bribed, intimidated, or who has disappeared. Why, one might ask, did the Kenyan delegation oppose the new Rule 68 and indeed try to inoculate the 2 Kenya cases from its effect? Surely the new Rule 68 is a wise response to widespread witness intimidation. Why oppose it? Instead of acting to secure justice for the victims at the ASP, the accused instead took steps to frustrate their search for the truth. Instead of championing the interests of the victims, he has worked against them. The accused's quest for immunity for sitting heads of state is also wholly contrary to the spirit of Article 143 of the Constitution of Kenya, which does not allow immunity from prosecution for the President in respect of Rome Statute crimes. When the Kenyan electorate overwhelmingly approved the Constitution in 2010, it can be presumed that they made an informed choice, and that choice included not shielding any future president of Kenya from prosecution for crimes against humanity. The accused's defence team has filed before this trial chamber application after application after application to seek to delay the start of this trial or to stop it taking place at all. That strategy of delay has been accompanied by a gradual escalation of anti-ICC rhetoric in Kenya. Together, they have had the effect of creating space for witness intimidation. The prosecution at page 2 of the annex filed on the 31st of January confirmed that the withdrawal of some witnesses, quote, appears to have been motivated, at least in part, by the anti-ICC climate in certain parts of Kenyan society. In the midst of a climate of fear in respect of cooperation with the ICC, one would imagine that the head of state would make a speech calling for full cooperation with this court and encouraging all those with relevant information to come forth and provide it to this court. The accused did nothing of the sort. Instead, he gave a widely reported speech in Addis Ababa on the 12th of October 2013, in which he said, "The ICC has been reduced into a painfully farcical pantomime, a travesty that adds insult to the injury of victims. It stopped being the home of justice the day it became the toy of declining imperial powers," unquote. On the question of race, he said, quote, "It is the fact that this court performs on the cue of European and American governments against the sovereignty of African states and peoples that should outrage us. People have termed this situation race hunting. I find great difficulty adjudging them wrong." Later on, he went on to affirm, quote, "We only get bias and race hunting at the ICC." end quote. In a later speech televised nationwide on Mashujaa Day, or Heroes Day, on the 20th of October 2013, the accused said in Kiswahili, "I want to assure you that this is an issue which will disappear. That devil will be defeated and Kenya shall move forward." In the context of the speech, it was clear that this was a reference to the ICC process. That word, shetani, means devil or demon or evil spirit. It is not a word to be used lightly. When the President of Kenya gives high-profile speeches in which he describes the ICC process as a racist process or as an evil spirit, Kenyan witnesses who have agreed to testify for the prosecution, either living in Kenya or with family members in Kenya, are likely to hear what he has said. Whatever anxieties they might have had about participating in the ICC process to begin with, those anxieties certainly will not have been reduced by such utterances. Others who have relevant information to provide, whether they are known to the prosecution or not, will be less likely to come forward and offer that information. And those who are wholly opposed to the ICC and feel the patriotic need to take action as a result can only feel encouraged and emboldened by these presidential pronouncements. Consider also how those speeches by the President of Kenya sound to a member of the Mungiki who has agreed to testify against the President. The Mungiki have good reason to fear. As every Kenyan knows, the Mungiki can be ruthless, and they in turn have received ruthless treatment from the state. In 2009, Philip Alston, the UN Special Rapporteur on Extrajudicial, Summary or Arbitrary Executions, issued a report confirming many extrajudicial killings of Mungiki by the Kenyan police. Alston told a news conference in Nairobi, quote, "Kenyan police are a law unto themselves. They kill often with impunity," unquote. Every Mungiki knows that the person who is today ultimately in control of the police is the accused in this case. Furthermore, the accused's invocation of racial bias to undermine the ICC is an insult not only to your honours, but also to the victims of this case, who overwhelmingly support the ICC process. The victims passionately and intensely want justice to be done. They know that justice is not a European nor an African invention, and that the thirst for justice is as universal as the thirst for water. They are entitled to justice not because they are African, not because they are Kenyan, not because they are Luo or Kalenjin. They are entitled to justice because they are mothers whose children were burnt alive. They are wives raped in front of their husbands. They are little girls whose fathers were beheaded. Apart from the speeches by the accused, there have been other events which have given rise to a sense of serious disquiet. In late July 2013, news of a confidential High Court application by the defence in this case was very widely reported in Kenya. The suggestion was that it related to data concerning victims and witnesses in this case. This led to significant distress in the victim community. That distress was not fully allayed by the defence after they belatedly clarified that the application in fact had nothing to do with victims in this case. Serious concerns about the safety of witnesses in this case persist. On the 5th of December 2013, this trial chamber had cause to issue this warning, quote, "The chamber recalls its finding above that the defence acted with serious disregard for the safety of its own witnesses. The chamber considers that this conduct risked endangering these persons and constituted a violation of the defence's obligations to respect confidential information and not to expose witnesses to unnecessary pressure outside the courtroom," unquote. The fundamental rights of the powerless can be denied by the powerful in many ways. One is to nakedly and openly attempt to bring a legal system into disrepute. An example of this is the accused's speech to the AU Special Assembly in Addis Ababa. But far more sinister is the denial of rights by neglect, inaction and obfuscation, by pretending that something is being done when in fact nothing is. An example of this is the policy of non-prosecution of post-election violence crimes by the Kenyan state since 2008, policy which has continued under the presidency of the accused to the present day. Domestic accountability for post-election violence crimes is a process which, as I mentioned, is deliberately going nowhere. It is a model of non-productivity. For example, take the multi-agency task force, sometimes presented as a principal vehicle for domestic accountability. As we are present here today, long after its formation, the task force has not released any public report on its work, nor any indication of its methodology, nor the time frame within which it will release its recommendations for prosecution. All the indications are that the task force is another smokescreen for continuing inaction. Kenyan human rights groups have filed constitutional petitions in the Kenyan courts against the government for the failure to investigate and prosecute perpetrators of post-election violence. Their applications have not achieved the aim of securing any genuine commitment from the Director of Public Prosecutions. They have instead been met with inordinate delay and obfuscation. In the international arena, the government of Kenya has made solemn promises to prosecute those most responsible. Promises that it hasn't kept. In a 31st March 2011 application to have these cases deemed inadmissible under the statute, the government assured the pre-trial chamber that Kenya would conduct its own prosecutions, quote, in respect of persons at the highest levels of authority and for the most serious crimes, unquote. The government in that 30-page filing to the pre-trial chamber made 7 references to its intention to prosecute those at the highest levels of authority. Today, 6 years after the post-election violence, and almost 3 years after the filing of that application, the government has in fact initiated not one prosecution against those at the highest levels of authority for post-election violence crimes. This non-prosecution continues under the presidency of the accused. It is entirely consistent with the total impunity enjoyed by high-level figures in the aftermath of the election-related violence in 1992 and 1997. That itself created an atmosphere of impunity which in part enabled the cycle of violence to be repeated in 2008. Impunity for the 2008 post-election violence crimes has been confirmed by domestic and international groups, in particular by Human Rights Watch in Turning Pebbles, which is a comprehensive 87-page analysis in December 2011. By April 2013, Human Rights Watch released an update in which it said that it had been able to identify convictions in Kenyan courts of only 7 cases, 1 vacated on appeal, involving serious crimes committed during the post-election violence. Amnesty International has released a report confirming police impunity for post-election violence crimes. That was in 2013. Impunity has also been confirmed by a report of Kenyan human rights groups in a report of April 2013. The Director of Public Prosecutions appears to pursue a policy of evasion. There exists no public report issued by the DPP identifying the names or even the dates of conviction of anyone convicted for post-election violence crimes. If you read all 82 pages of the strategic plan for the Independent Office of the Director of Public Prosecutions, which was released in March 2012 and covers the period until 2015, you will find one single reference to post-election violence crimes. That is a reference to, quote, the expectation on the ODPP to prosecute cases including high-level corruption and PEV, end quote. But the Director makes no reference at all to any intention, let alone a strategic plan, to investigate or prosecute post-election violence cases at any level. The International Crimes Division, or ICD, of the High Court, sometimes presented as Kenya's answer to the impunity issue, remains wholly unoperational. It does not exist. In any event, the Attorney General reportedly made comments on 30th of April 2013 that the post-election violence, quote, is not the primary reason why the ICD is being set up, unquote. The continuing state of non-prosecution over which the accused presides is not due to post-conflict difficulties as might have arisen in Rwanda or Bosnia. Kenya has technologically advanced courtrooms and an excess of qualified lawyers. What is missing is the will to prosecute, and genuine responsibility for that ultimately lies at the top of the government. The accused, to my knowledge, has never expressed support for the investigation and prosecution of post-election violence cases to the highest levels, nor to any level. And why not? The accused has frequently said, whether to BBC or Al Jazeera or to others, that he wants to go to The Hague to clear his good name. Why, with all the presidential powers at his disposal, is he obstructing the emergence of the truth in Kenya? What has he got to hide? Why doesn't he do something, anything, which would genuinely facilitate domestic accountability for post-election violence crimes? Instead of supporting the creation of domestic structures which would assist the victims to know the truth about what happened in the past, the accused on the 7th of September 2013 told internally displaced persons to forget the past. That's according to a press release issued by State House itself. The accused's effort to obstruct the emergence of truth at the domestic level has taken place in parallel with an effort to obstruct the emergence of truth at the international level. This has taken place in the form of state obstruction of access to evidence by the prosecution in this case. That policy has been in place since well before the confirmation stage and has surely resulted, at least in part, in the prosecution's over-reliance on the evidence of a very small number of witnesses. Nothing confirms the impact of pre-confirmation state obstruction more clearly than the issue of police crimes. As your honours are aware, crimes committed by the police no longer form any part of this case. Yet there are credible indications that from Mombasa on the Indian Ocean to Kisumu on the shores of Lake Victoria, from Nairobi to Eldoret, that the police shot dead at least 400 victims. The number in the Waki report is 405. Hundreds of other Kenyans were shot by police and survived. Everything suggests that there had been, at the very least, a failure to prevent and punish police crimes on an extensive scale. Yet the prosecution failed to persuade the pre-trial chamber to confirm charges against the former police commissioner, Mohammed Hussein Ali. It is clear that the single biggest factor underlying that failure was state obstruction of access to evidence. The prosecution was prevented from interviewing 10 key police officers due to an interim injunction that is still in place today, 3 years after it was issued. The Attorney General, who is a party in the case in which that temporary order was issued, did not challenge the application for the order, nor did he appeal against the ruling, nor did he seek to have the order dismissed, nor did he ask for the matter to be sent forth for a full hearing. Instead, he has in fact used that interim order to justify the inaction of the government of Kenya. It's in his filing of the 9th of April 2013 in paragraph 42. Now, at the prosecution hearings, where, as we know, the prosecution was completely prevented in accessing 10 key police officers, the Muthaura and Ali defence submitted 39 written statements from police and other law enforcement officials. As the prosecution noted in its filing of 10th of May 2013, paragraphs 20 to 24, those statements were taken after the issuance of that temporary injunction, preventing the prosecution from interviewing 10 key police officials. The deliberate blocking of access by the prosecution, but not the defence, to police evidence is not a small matter. It could well be the principal reason why today nobody has stood trial before this court, nor before any Kenyan court, in respect of police killings during the post-election violence. And in no circumstances can there be any possible justification for any state party to block access to its own police force when in receipt of a legitimate request from the Office of the Prosecutor. I'd like to focus briefly on the question of obstruction of access to telephone data. The successful deployment of systematic attacks in Kenya in January 2008, whether against perceived ODM supporters or perceived PNU supporters, unquestionably required the extensive use of mobile telephones to send oral and text instructions. Kenya is a regional leader in mobile telephone usage and a world leader in mobile telephone banking. Phones were widely available in Kenya and calls were cheap in early 2008. And yet we see from the annex to the prosecution's filing of 31st January 2014 that the prosecution was misled as to the availability of data, obstructed in trying to access it, and provided with data which had been fabricated. 4 years into its investigation, the prosecution has clearly struggled to gain access to this absolutely vital category of evidence. In contrast, the UN team which investigated the assassination of former Prime Minister Rafik Hariri in Beirut in 2005 had amassed 2 years after that assassination more than 5 billion records of telephone calls and text messages sent through cell phones in Lebanon. Even accounting for different rates of mobile telephone penetration in Kenya in 2008 and in Lebanon in 2005, it is clear that there is likely to exist in Kenya today a huge quantity of useful phone evidence. The prosecution has been seriously hampered in its access to that evidence. Your Honours, mobile telephone companies in Kenya are amongst the biggest taxpayers in Kenya. Safaricom, for example, is in fact the biggest taxpayer in the country. Their licenses are subject to renewal by the government. It is, I suggest, unlikely that any Kenyan mobile telephone company would act in such an obstructive manner to the prosecution of its own volition without receiving instructions from elsewhere. Your Honours, the litigation concerning the financial information in this case is subject to parallel proceedings, and Your Honours have said that you don't want to receive submissions about that. I would simply like to point out that the nature of the submissions filed by the government on the 20th of December 2013 and notified on the 9th of January 2014 are, in my view, a perfect illustration of the government's evasive and disingenuous attitude towards cooperation. Its submissions concerning the operation of the right to privacy and of the operation of the principle of self-incrimination defy belief. In particular, the invocation of the self-incrimination privilege is illuminating. The government's considered view by the government's principal legal advisor appears to be that a state authority cannot disclose to a prosecution service incriminating information relating to a suspect without going to the suspect, asking him for his permission, and then getting that permission from him. I would respectfully suggest that in no jurisdiction in the world does such a position exist. The acceptance of such an interpretation would render the state cooperation provisions of the Rodent Statute wholly meaningless. In addition to the imaginative legal barriers the government offers, it has made no effort to explain why it has failed to act without delay, as required by its own legislation and, as I mentioned earlier, by Articles 93.3 and 99.4 of the statute, to bring those purported legal barriers immediately to the trial chamber. Now, the prosecution at the bottom of page 6 and the top of page 7 of the confidential version of its annex of 31st of January 2014 has identified some key documents. I would respectfully differ with my learned friend Mr. Gumpert as to the potential value of those documents. In my view, we cannot describe them as pebbles rather than stones until we have seen them. They, in my respectful submission, are documents which Your Honours are entitled to see. The dates and descriptions of those documents stand out like a beacon. What possible justification can there be for withholding those documents from Your Honours? It is not disputed in this case, as far as I'm aware, that terrible crimes took place in Naivasha and Nakuru in January 2008. What possible justification can there be for withholding them? They would surely assist in clarifying exactly what happened and who is responsible. What is the accused government doing by trying to hide them? What has the accused got to hide? Further, the victims of this case are Kenyan citizens and are entitled to justice at this court, both under the International Crimes Act of Kenya and the Rome Statute. That includes knowing the truth about the crimes committed against them. The accused should show his commitment to justice for those Kenyans by disclosing those documents without delay. Your Honours, if we can slightly shift our attention for a second to the United States Supreme Court. When I saw that list of documents identified by the prosecution, I was reminded of nothing so much as a 1974 case in the United States. President Richard Nixon, who was, of course, the head of government and the head of state of the United States, had withheld from a special prosecutor audio tapes and documents relating to precisely identified conversations and meetings between the President and others. President Nixon, who was named as an unindicted co-conspirator, claimed that he was entitled not to disclose the tapes and documents due to executive privilege. The United States Supreme Court unanimously rejected Nixon's interpretation of executive privilege and ordered him to hand over the tapes and documents in question. That's United States against Nixon 418 U.S. 683 of 1974. Nixon duly handed them over, resigned 2 weeks later, and was granted a pardon by his successor, President Ford. But that decision stands for the principle that no matter how powerful the suspect, even if he is the most powerful individual in the world, his interest must yield to, quote, a demonstrated specific need for evidence in a pending criminal trial, to use the words of the US Supreme Court. And that is exactly what we have here. Your Honours, the failure of the accused to secure state cooperation in this case is particularly reprehensible, given the fact that the court has already made very generous accommodation to him. He has not been to the ICC since October 2011. To reiterate, not once in 2012, 2013, or so far in 2014 has he in fact set foot in any ICC courtroom. Of the hundreds of persons indicted for serious crimes by the ICC, the ICTR, the ICTY, the Special Court for Sierra Leone, and the ECCC since 1994, this accused has in fact treated with more deference than any of them. This itself is offensive to the victims of this case, and that offence was only compounded by a recent application by the accused, in which he clarified that he does not even want to be present in court for the opening statements in this case, which of course concerns brutal crimes committed against many thousands of Kenyan citizens. I've pointed out in my written submissions the difference between the situation of Laurent Gbagbo, who has no power over the current government of the Côte d'Ivoire and is in custody here in The Hague. This accused is in full control of the government of Kenya, which has impeded access to relevant evidence, and he is at liberty. The very least that justice demands is that equal respect be paid to the victims in this case as to the victims in the Gbagbo case, and that the prosecution's investigations continue until state cooperation has been fully delivered. Your Honours, what can you do about the extensive state obstruction which has infected the entire history of this case? First, Your Honours can and should order the immediate disclosure of the documents identified in the prosecution's annex of the 31st of January, in accordance with your powers under Articles 64 and 69, if the accused and his government continue to refuse to disclose them. Second, Your Honours are seized of the application concerning non-cooperation by the accused government, and you should rule on it. Third, the trial chamber should look closely at the question of whether the accused's failure to enable access to relevant evidence in this case is consistent with the summons conditions in this case. I refer to the conditions imposed on the accused on the 8th of March 2011. Under those conditions, the accused is obliged to refrain from, quote, obstructing or interfering with the attendance or testimony of a witness, or tampering with or interfering with the prosecution's collection of evidence, unquote. Your Honours, you must not flag or fail in your efforts to do justice in the face of continuing state obstruction of access to evidence by a government headed by this accused. The easy option is for this court to raise the white flag of surrender. But this would send out a devastating message for others to consider. That message is that state obstruction of access to evidence is a viable strategy. It is a message that cannot be allowed to stand. Terminating this case without taking all the measures available under the statute to force the accused to direct his authorities to provide the information requested by the prosecution would render meaningless the carefully calibrated model of state cooperation set out in Part 9 of the statute. Termination in such circumstances truly would be, quote, a travesty that adds insult to the injury of victims, unquote, to borrow the accused's expression from his 12th October speech at the African Union. If the charges in this case are dismissed, there will unquestionably be a widespread perception in Kenya and elsewhere that the case against the President of Kenya is collapsing under the combined weight of witness intimidation, bribery, and state obstruction of access to evidence. To terminate proceedings against Mr. Kenyatta while he presides over an administration that is clearly obstructing access to relevant witnesses and documentary evidence would have a devastating effect on the court's deterrent effect. Deterrence, like a currency, can be debased or devalued. We can reasonably differ about the strength of the court's deterrent effect, but there is no doubt that that effect does exist. It was perhaps the very threat of ICC prosecution which deterred election-related violence in Kenya in 2013. But the open expressions of contempt by the accused for this court have already debased and devalued the deterrent effect of this court. This cannot stand. Already this year in the Central African Republic and in South Sudan, we hear of appalling atrocities which cry out for the strengthening and not the weakening of the court's deterrent effect. Over 4 years ago, the victims of this case and a huge number of other Kenyans were first led to believe that the ICC would deliver justice to the thousands of Kenyans targeted because they were perceived to be supporters of a particular political party. In this case, during the post-election violence, being a Luo, a Luya, or a Kalenjin was a crime in itself, punishable by death, gang rape, forcible circumcision, or castration. Tens of thousands were expelled from their homes, which were themselves ransacked or burnt to the ground. To this day, hundreds of thousands of those expelled during the post-election violence live far from their former homes, displaced to what are considered to be their ancestral homelands in the western region and the Nyanza region of Kenya. And they are too afraid to return to where they once lived and worked, and they have received next to no assistance from the government whether under this accused or under his predecessor. Tragically, the ICC cannot intervene everywhere that atrocities are committed. But where it does intervene, it raises hopes for justice in the hearts of tens of thousands that cannot simply be crushed underfoot. The victims of this case have a legitimate expectation that this court will do all that it can do to reveal the truth of the atrocities that engulfed Naivasha and Nakuru in January 2008. It would be unconscionable now to abandon the thousands of victims of this case at this stage before they have heard even a single day of trial. The process of justice for the Kikuyu victims of the horrific crimes alleged in Case 1 is underway. It must continue. Yet to bring justice only to Kikuyu victims of the post-election violence and to abandon the Luo, Kalenjin, Luya and Kisii victims will not enhance the reconciliation process in Kenya. Further, a conviction of either accused in Case 1, accompanied by a withdrawal of charges in this case, is also unlikely to enhance the chances for reconciliation. Your Honours, just last week the accused told an AU summit, his words were, quote, "During the extraordinary session of the summit held in October 2013, we reaffirmed our commitment to fight impunity, promote human rights and democracy, the rule of law and good governance," unquote. Yet his administration and the administration in which he was Deputy Prime Minister have together brought not one high-level or mid-level suspect to trial for crimes against humanity committed against thousands of Kenyans in January 2008. He has done nothing to fight and everything to reinforce impunity for post-election violence crimes. Under the accused's leadership, anti-ICC rhetoric in Kenya, with the accused setting the example, has increased considerably. Disingenuous expressions of cooperation with this court are now accompanied by genuine expressions of contempt for this court. Instead of some movement in respect of domestic prosecutions, we now have total stasis in respect of domestic accountability for post-election violence crimes. I referred earlier to a woman I met who was gang raped by Mungiki attackers and then doused in paraffin and set alight. She was lucky to be rescued. 9 months later, she gave birth to a little boy. His biological father is a Mungiki rapist. The woman explained all this to her husband, who, as you will recall, was himself hacked repeatedly by the Mungiki and left for dead on that same day. He understood his wife's hellish predicament, and today they are raising together that little boy. Conceived through rape, he is being raised in love. What does he, the husband, what does he want, taking into account the horrors that he and his wife were subjected to? His answer is justice. With justice, he told me, there can be reconciliation. But if there's no justice, he says, he won't be able to find it in his heart to forgive. For there to be true reconciliation, there must be truth. For there to be truth, there must be evidence. All the evidence that is necessary to uncover the truth. For there to be evidence, there must be state cooperation. And for that, the accused must give the order. If your honours do not do justice in this case for the victims, nobody will. Justice ultimately is truth. It is the whole truth in all its measure. It is a rejection of those who try to create obstacles to reaching that truth. It is a rejection of false arguments based on racism promoted in an effort to avoid accountability. Your Honours, they say in Kiswahili, haki hu inua taifa. Justice elevates a nation. Kenya's policy of evasion and obstruction must be replaced with a policy of truth and transparency. It would be wholly unjust to consider the insufficiency of evidence in this case as unrelated to the ongoing policy of obstruction. The detailed and delicately balanced model requiring state consultation and cooperation in order to secure the production of evidence relevant to this case as set out in Part 9 of the statute, should not be set aside. To terminate proceedings in the exceptionally unusual circumstances of this case, before first securing the fulfilment by the accused government of its duty under the statute to provide all the evidence relevant to this case, and not just the evidence which is the subject of the prosecution's Article 87(7) application, would be unjust. It would be a rich reward for an accused who has presided over the continued deployment of a policy of obstructing the emergence of the truth, and would be a devastating betrayal of the thousands of victims in this case. Thank you, Madam President.
Thank you very much, Mr. Gaynor. Now, prosecution, we will return to you, and please respond to the points that have been made by the defense, as well as legal representative as appropriate. And from the bench, we would also like you to address the following question. In light of the admission that you do not at this stage have sufficient evidence to meet the required standard, and that you are not sure whether you can get sufficient evidence even if government of Kenya will comply with your request, on what legal basis do you consider it appropriate to seek a continuation of the proceedings, in particular with regard to the provision of Regulation 60 of the Regulations of Office of the Prosecutor?
When Your Honour speaks of Regulation 60 of the Regulations of the Office of the Prosecutor, the bundle of documents which I have in front of me concerning regulations contains the regulations of the court and those of the registry. Do I take it that it is to neither of those that the court is referring?
No, it's OTP regulations I'm referring to. You can come back on this point in the afternoon if you do not have answer right now.
Well, I frankly concede that that regulation was not uppermost in my mind, and since if there is to be an afternoon session, I would be better able to give a considered reply to a matter which is obviously of concern to the bench, then I would ask for that indulgence.
Okay. So please proceed on other points.
Indeed. I have no reply, or indeed, I have nothing to say in respect of the remarks which have just been made by the representative of the victims, Mr. Gaynor. Mr. Kay, in his submissions, did not deal with issues of whether it was necessary for the court to grant its approval before a case could be withdrawn, or of whether the court had power to dismiss the case under the relevant Article 64, and therefore I have no response to make. My position remains, as set out in writing, that any determination of those issues for the present would be premature, that the issue for the present must be whether the determination of the cooperation issue must logically come first, and that this trial should be adjourned until that decision has been made. I'm slightly reluctant to make submissions in reply because in your instructions to both counsel, you were very clear, Madam President, that we shouldn't seek to argue the merits of the cooperation issue. Now, There's been talk of a blame-shifting exercise, and I hope I'm not going to indulge in that now, but much of what Mr. Kay said was indeed about the merits of that precise matter, and I don't accept all that he said. I think, however, I can summarise it very briefly, rather more briefly than the submissions that he made. The position is not that the government of Kenya has been consistent in saying that it has no duty to comply with requests for assistance when made by the prosecutor, and a duty only to comply with requests which are sanctioned or made by the trial chamber, or indeed any other chamber. Indeed, as recently as November, at the Assembly of States Parties, the government of Kenya, through the Attorney General, who was present, as Mr. Gaynor remarked, stated publicly that it was in full compliance with all requests for assistance. If there has been any shifting of ground, I would respectfully submit it is in the novel proposition, now at least clearly expressed, that it would be improper, perhaps even illegal, for the government of Kenya to assist in respect of requests made by the prosecutor. It's particularly novel because, of course, at least in part, rather unhelpful part, but nonetheless in part, the government of Kenya has responded to requests made by the prosecutor, not sanctioned by the court. So there's an element of contradiction in the behaviour of the government of Kenya. The prosecution is not engaged in a blame-shifting exercise. The prosecution acknowledges that the case it hoped to bring has been undermined by the events which are set out in the document in which we first seized the court with the fact that the evidence was no longer sufficient. And that, we concede, was not a question of non-cooperation. But there has been a lack of cooperation, and it would not be right, as Mr. Gaynor has said, for this case to fail and for the prosecution to be forced to withdraw the case, as we may be in due course, if the evidence does not emerge, in the light of the fact of the sustained and deliberate obstructionism of the government of Kenya. Those are all the remarks that I have to make in response to those made by Mr. Kay. I see that it's 11:45, and I'm going to take the very kind indulgence offered by the court to consider the answer to the question which the court has in the light of Regulation 60. Would Your Honour, it may be that unless there is more to be said by other parties, we will be able to take a break in short order now, which we're rather early for a lunch break, but perhaps we don't need to be constrained by our normal eating habits. It would be sufficient for me if there were to be an hour from whenever we break, and we could come back thereafter, if that meets with the court's approval.
Thank you very much.
Before Your Honour rises,
Yes,
I'm so
Mr.
sorry. May I raise one matter? You did say we weren't to repeat submissions. Mr. Gaynor has spent a great deal of time this morning repeating his filing, and I seek an opportunity to reply, as there are matters within his submissions to the court that require me to address them in relation to the actual position and factual position of what has taken place. I wouldn't propose to be very long about it, but it's very important that there is a balance in these proceedings, as I'm sure the court will agree. And in a highly political speech, in my submission, there are issues of justice that weren't addressed that have to be put before you and the public this morning. And we were mindful of your directions at the start of the proceedings, but we think it only fair in the circumstances that we be given an opportunity to respond, because very serious allegations have been made, and it wouldn't be right for the matter to be left there. There will be many people feeling that comments have been made in this court today which weren't supposed to be made because of filings that had taken place, that would feel that a necessary response had not been permitted.
Thank you, Mr. Kay. Of course, defense will be, excuse me, will be given chance to respond to any of the submissions made by the other party or by legal representative. And I also partially agree with you that to some extent Mr. Gaynor's statement was a repetition of what he submitted in writing. But because this status conference is a crucial status conference to discuss the issue of the future, entire future of these proceedings, the bench intentionally decided to listen as much as possible to the voice of victims, because this procedure has an immense impact on the rights and interests of the victims. So if there is no participant wishing to take floor right now, we'll rise, and court officer, when can we resume? We will resume at 1:30 in this same courtroom. The hearing adjourned.